I'm really pleased to welcome today Dave Thompson of the Scottish Government's Community Land Team. We'll be talking about the various acts which support community right to buy, and some of them now quite old, some of them quite new, but all of them world leading in terms of the rights that they give to communities to acquire land and building assets that are important to them. So Dave will talk for about 30 to 40 minutes about the various community right to buy options that are available to communities and what differs between them, which route to take depending on which situation you're in. This builds on from the session that Lindsay and Christina delivered this morning, specifically around community asset ownership and the routes to ownership. So this is a really important route to ownership using the community right to buy, and Dave can give you a bit of background as to the circumstances in which you should be using it. So we'll have an opportunity for questions at the end. So if everyone could use the chat function, which if you go to the bottom of the screen, you'll see a function which allows you to type in questions on the sidebar. And if everyone's okay with that, we'll use that as a route to collating all the questions. And then when Dave's finished his presentation, I'll ask those questions of Dave at the end. So I'll work through them and try and group them together if appropriate. So a little bit of housekeeping. Everyone is muted from the start, so if you could keep your mute button on while the presentation goes ahead, and that makes sure we can all hear what Dave's saying. As I said, if you could use the chat function for questions. We're also recording the session, so if you're not able to stay for the whole session or you want to listen again, if there's something in particular that you're not too sure about, you can listen again, and obviously you can also share the webinar session with colleagues who you think might be interested. And equally, if we either don't get to your questions or you think of a question after the event, then please feel free to drop us a line and we'll try and answer that question after the event. So I'll pass you over to Dave now. Community Land Scotland, as Lindsay would have explained in the first webinar, if you're in that webinar, are the voice of community landowners in Scotland, and we've been able to support quite a few of our members using these particular pieces of legislation, which Dave will talk through now. So again, any questions at the end, but if you want sort of broader advice on community right to buy, then do get in touch with Community Land Scotland after the event. So I'm going to mute myself now and pass over to Dave, who's got a presentation, and talk that through for you. Okay, thanks.
Right, thanks, Elsa. Again, hopefully we can hear me. I will just take 2 seconds to set up and share the presentation. And hopefully you can confirm that everyone can see that. That should be okay. Everyone hear me okay? I'm just waiting some confirmation before I get started. Right, perfect. Thanks, Christina. Okay, as Elsa was saying, my name is Dave Thompson and I'm head of the Community Land Team within the Scottish Government. To give you a little bit of background, the team deals with 2 main areas of work. One is the Scottish Land Fund, where we have oversight of the fund which the Scottish Government funds to the tune of £10 million a year, and hands down as enterprise, and the National Audit Community Fund administer that for us on our behalf. And the other main part is the various community rights to buy. The team's involved in that from their inception to taking legislation through Parliament and now to the operational aspects of it. So we've got a very much an in-depth knowledge of the rights to buy, how they work, how we intend them to work. And so I will take you through them just now. Now, at the moment, there are now 4 community rights to buy in operation. The final one came into force in March of this year. That's basically the community right to buy, which we refer to as Part 2. We often refer to the parts number because it's a lot easier to say and a lot shorter. The community right to buy came in 2003 as part of the original Land Reform Scotland Act, And what that gives is community groups an opportunity to register an interest in land, and by land I mean land, buildings, etc. It gives a community group a chance to register an interest so that even when an owner decides to sell, that community group is given the first opportunity to buy. So it's not a compulsory purchase, it's a registration of interest. It generally takes 2 stages. One is the registration itself, and that can sit for a period of time up to 5 years before being re-registered. Now the owner triggers the second phase, which is puts the asset up for sale. Then that second phase kicks in, and that's when the community group are actually given the opportunity to buy it. But that really is a registration of interest. At the same time, the Crofton Community Right to Buy came in, which is part 3. Now, I'm not going to touch on that one today, but if anybody does want to know more about that, they can feel free to get in touch, and contact details will be at the end of the presentation, and I'm sure Community Land Scotland will provide them for you if need be. That is a compulsory purchase, but obviously only referring to Croftland. So it's only been used twice since 2003 when it came in, and never to completion. In both cases, the community groups negotiated a sale out with the Act with the owners of the estate. So it's there to be used, but hasn't been used in anger all the way through as yet. The third one is the community right to buy abandoned, neglected or detrimental land, what we call Part 3A. That came in 2015 through the Community Empowerment Act, really came into force in 2016. That is a compulsory purchase right, which means that if successful, a community group is given the right to purchase the land, whether or not the owner wishes to sell. But obviously only in particular circumstances. And again, I'll touch on that as I go through the presentation, but the title says it all, the land must be abandoned, neglected or detrimental. And the final one, which is also a compulsory purchase, came into being in March 2020, or came into force rather, and the right to buy land to further sustainable development. Very similar to the Part 3A about abandoned and neglected, but obviously now it's to further sustainable development. So the condition of the land is not the main thrust of this one, it's what the community group will be able to do with that land should they acquire it. Again, a compulsory purchase largely operates in the same way as Part 3A with the various steps. Maybe one of the key things to note just now is that this final right to buy also gives the community groups the opportunity to name a third party purchaser. In this case, the group themselves still have to put the application in, but they can name another party to actually act as a purchaser at the end of that one, which is why it doesn't have the word community in it. So that's the 4 main rights to buy. I'll concentrate on the comparisons between the Part 2, Part 3 and Part 5, because they generally have the same steps that community groups have to go through. And as I go through the comparison of the steps, I'll try and explain a little bit about some of the requirements. It's by necessity going to have to be a bit of a whistle-stop tour, but we'll try and get through as much of it as possible. So you've got the 3 parts there. The Part 2 is the only non-compulsory one. That's, to keep that in mind. The other 2 are compulsory. The first step for any of them is that we ask community groups to be one of several compliant structures. There are requirements in the Act in particular about the size of that structure in terms of the number of members, also where those members come from, that are not the vanilla type, if you like, of things that might normally be expected through company law, for example. So it's important to engage with the community land team or CLSD task costs. You can also offer advice on that one, but ultimately, at the end of the day, for a group to be able to access any of the rights to buy, they must be a compliant community body, and that is only the case when we give them a letter that says so. So at some point or another, it still has to come through this team. So the structures for Part 2 are the Company Limited by Guarantee, the Scottish Charitable Incorporated Organisation, or the Community Benefit Society. So any one of those 3 is fine. Just of it in terms of membership is minimum of 10 members, must be geographically defined community. It's not communities of interest, has to be geographically defined, but that can be through a number of different ways, whether it's postcodes, council wards, electoral wards, islands, location, settlement, whole range of things. The basic building block of which is the postcode. For Part 3A, it's the same three structures. We tried to keep the different rights to buy as similar as we possibly could, so that community groups out there didn't have to change too often. For Part 5, there's an additional one. Still the same three. The body corporate at the end there is only available if the community group is going to be naming a third-party purchaser. It's not quite as rigid as the other three in terms of the requirements, but there are still some in terms of the minimum membership, and it's still about a geographic community. But at the end of the day, the community group will not become the owner. So this fourth type of structure is allowed under Part 5, but only if they're going to nominate a third-party purchaser. So once the group becomes compliant, they have the letter from us. There is some pre-application work required for some of the parts. For Part 2, there is none. Once you're compliant, you can apply straight away, but you can't apply until you are. What I would say on that, though, is that we are always willing to look at draft applications whilst you're becoming compliant. So if you're pulling together your articles of association, etc., feel free to still get in touch about your application. We'll be able to tell you what sort of things we're looking for. You can start preparing that before submitting it, but you'll not be able to formally submit one until you become compliant. For Part 3A, the abandoned and neglected, compulsory purchase, we never, for Part 3 or 5, any of the compulsory purchases, we never want that compulsory purchase to be the first step any group takes in acquiring land. We'd always prefer, even under any of the rights to buy, that land was acquired through negotiated sale. That gets the best outcome for both parties. However, should they wish to go down any of the rights to buy, for Part 3A, the abandoned and neglected, they must have already tried to buy the land, and they must have tried to do so as a compliant community body. So get that compliance letter from us first, then try to buy it. If you wish to use the detrimental element as opposed to abandoned and neglected, by detrimental we mean harmful to the environmental well-being of the community, and that can be environmental harm, social harm, economic harm, whatever. You try and explain to us what that harm is. You tell us what the harm in the community is. If you're relying on the detrimental element like that, you must have also, in addition to trying to buy the land, have contacted the relevant regulator to try and fix the harm. So again, if the issue is something constantly flooding that the owner is just not dealing with, your first step should be to contact the relevant authority to try and get the owner to deal with the flooding issue. The first step shouldn't be trying to compulsory purchase the land to do it yourself. But if that doesn't work, by all means, use the Act. So that's two prerequisites for Part 3 on the abandoned, neglected or detrimental. Part 5, again, compulsory purchase, has a similar pre-application amount of work, but this time it's asking the owner to transfer. And that must have been done at least 6 months before applying. That's to give time for the owner and the group, because in this case the land isn't abandoned or neglected necessarily. So the owner may be doing something or trying to do something with the land at that point in time. So it's to give time for some negotiation before the group put the application in. Again, you must be compliant before you ask the owner for that transfer. So again, become compliant first, then contact the owner in terms of transferring. After the 6 months, you're more than welcome to put in an application or continue negotiations or whichever. So that is the pre-application work required for parts 3 and 5. Now, as part of that, we want to make sure that it's the community behind this idea and not a small group of individuals or a large group of individuals for that matter. But at the end of the day, it's about community right to buy. So we want to know that the community are also in support of the ideas. For part 2, keeping in mind that this is, at this point, only a registration of interest, not about the purchase yet, a petition is sufficient, and we would expect to show at least 10% of the community that you've defined showing their support. It's got 15% for late applications there. What we mean for a late application is that the application comes in after the owner has already taken steps to transfer the land, i.e., usually by selling it. So whilst an owner puts the land up for sale, that doesn't stop a Part 2 application. There is an additional test because we're now interfering with a live land market. So we expect more demonstration of community support for that, amongst other things. So it's a petition, you can collect it any way you like, but it has to be physical. Online petitions are not acceptable at the moment, or simply because we have no way of checking that. Because we have to check that that petition is a valid petition, the people who sign it are within the community, and that they are eligible to sign that petition. So we need to have something to check. So it has to be physical. And I realise at this point in time that's going to be difficult to do. And at this point, I don't know of any ways that communities are trying to get around that. But if you do have an issue with that one, then get in touch and we'll see if there's something to do. But it still has to be a physical petition. So online petitions aren't eligible. For Part 3A, remember this is a compulsory purchase. So if we approve an application under Part 3A, that's straight to the purchase stage. There's no waiting on somebody triggering a sale. That's straight to purchase. So for that reason, Part 3A requires a ballot of the whole community. Now that's a secret postal ballot where we expect, in rough figures, these aren't hard and fast, but these are an indication of what we'd expect, is a 50% turnout and 50% of those who do vote being in favour of the compulsory purchase. The costs of the ballot, relevant costs of the ballot, can be claimed back once the group submits an application. So although they'll have to initially outlay the costs of postage, envelopes, stationery, etc., they can claim those back once they submit the application. And that's just relevant costs, not costs associated with the big party to celebrate the outcome or anything like that, just the relevant costs. So as I say, postage, stationery, etc. Under Part 5, it's the same. There's a ballot. The results of that ballot have to be sent to us, either as part of the application or 2 weeks after the result of the ballot. And that will be used as part of our consideration of whether or not to approve. We need to see that demonstration of support. Once all those steps are in place, the application comes in. Under Part 2, when the application comes in, there's a prohibition placed on the owner. Now what that does is it legally stops the owner from transferring the land to anybody else until we have considered the application. If we subsequently approve the application, that prohibition remains in place for up to 5 years, which can be renewed. If we reject the application, that prohibition is removed and the owner is free to sell on the open market. There's an entry in what we call the RCIL, which is the Register of Community Interest in Land. That is held by the Registers of Scotland. So if you go to the ROS website, you'll be able to find that there. That holds the details of all the applications we've received under Part 2, whether they were rejected or accepted. So it's a useful tool to have a look and see what sort of things we look for, what other groups have put in applications, the sort of documents they provide, and equally why we reject or accept some cases, because the decision letters will also be in there. So it's a useful tool for that. But as soon as the application is received by us from the community group, it's placed in the RCL, so it's there for anybody to see straight away. We will also send a copy of that to the owner, and I'll touch on those next steps in a sec. Under Part 3A, prohibition is also placed. It's a different register. It's still held by Registers of Scotland, but it's a different register. And that ROCABLE stands for Register of Applications by Community Bodies to Buy Land. Bit of a mouthful, just call it ROCABLE. But it's the same essence. It's got details of the application, all the maps included, etc., etc. At the moment, there are only 3 cases on it, I think. Certainly 2, but I think maybe the third one should be there by now. And that, again, is a good source as that builds up of community groups to be able to see, well, what works, what doesn't work. The slight difference from Part 3A is that when the community groups send the application to us, they also have to send it to the owner themselves. Under Part 2, we get the application and then we send it out. Under Part 3A, they have to send us and the owner and heritable creditors, etc., a copy of that application straight away. So the owner gets it at the same time as we do, and then just ahead of when the prohibition goes in place. Same restrictions on the prohibition in place. The owner cannot transfer, and if they're in the process of transferring, they must stop. That applies to Part 2 as well. So if they're already i.e. a late application under Part 2, in the process of transferring, they must stop that transfer. That can then continue if we reject the application, but they must stop it straight away. They can't finish that off. Basically, any time up to missives are signed, essentially, that can happen. Exactly the same for Part 5. It's placed in the same register as Part 3A. It'll be obvious from the reference numbers are given which ones are which, but it's all the same information that's there. So the applications are there in the public domain for anybody to see. Owners are given the opportunity to comment on applications. It's an open process. We have to balance up all sides of the argument, if indeed there is an argument, to make sure that it's a fair decision. Under Part 2, the owners are given 21 days to respond to that application coming in. Under Part 3A, they're given 60. It's a compulsory purchase. You know, they need more time to, and given it's compulsory purchase, it's probably a more, I suppose, complicated argument they may try to make against it, but essentially they've got 60 days. Keep in mind, though, that the group should already have tried to buy the land off the owner, so they have had a heads up that something's in the wind. So it's not as if it should come as a complete surprise, but we're still given 60 days in which the owner to comment on that. And what we look for the owners to do is basically tell us, you know, what it is they're doing with the land, why they don't think the group's application meets public interest tests, meets furthering sustainable development tests, why it's not the best thing for the land, why what they're doing with the land is absolutely fine. Under Part 5, they're given the same amount of time because it's a compulsory purchase in a similar way to Part 3A. Now, I've said it was an open process. So once the owner's comments come in, the community group are given a chance to come back on those comments, to either to correct misapprehension or misunderstandings or to clarify aspects of it. But essentially, they're given 21 days to do that. 0 if it's a late application. So the late application is where the owner's already tried to transfer. If that's the case, the community don't get a chance to respond because, again, there was a transfer already in place. So we don't want to hold that up too much. So they don't get a chance to respond to that. Under Part 3A and Part 5, the group are given 60 days to respond to those comments. Again, because of compulsory purchase, they're probably going to be quite lengthy. The group will need time to pull together their comments on that, so we give them 60 days on that. At which point we have all the information from groups. What I would say is on all of those that because the applications are made public, members of the public can also comment on those applications if they wish. We have to take all of that into account in our decision. What we do is we take all that and then we make a recommendation to the Cabinet Secretary, Rosanna Cunningham. It's her that will make the decision, not us, but we will make a recommendation to her based on all of that information. The remainder of the 60 days, 63 days rather, under Part 2, is used up for our decision. So you've had 3 weeks for the owner's comments, 3 weeks for the group's comments. Ideally, we'd get 3 weeks to decide on a case, recommend to the Cabinet Secretary, and then for her to make that decision. Again, it's a late application because the process has already started of the transfer. The owner would have 21 days and we'd have 9 days left to make our decision. If we're late on that, that doesn't affect any of the rights and any of the rest of the process, because quite often for late applications, we don't know it's late until the owner comes back with their comments to say, well, actually, I'm in the middle of selling this one, and that's the first time anybody hears about it. So quite often late ones become late, quite late in the process, as it were, so that we don't have a lot of time to react to that one, which is why if we're late with our decision, it doesn't affect any of the rest of it. For the other rights to buy, the decision will come on to in the next page. The trigger. Part 2 I mentioned is a 2-stage, where the first part is a registration of interest. Second stage where the owner decides to transfer. That's the trigger. The registration, as I've said before, can be re-registered every 5 years. Under Parts 3A and 5, there is no trigger because you're already straight into the purchase element. either once that trigger is done or for parts 3 and 5, once we've received the application, we will order evaluation of the property. That doesn't stop both the owner nor the community group doing their own, but what it is we will ask for an independent evaluation by the district valuer or whoever the contract is with at that time, so that is then used as the baseline cost. Somebody else coming in. That baseline cost is what is used to determine the price to be paid. That doesn't stop the owners and the group agreeing a different price, whether that be lower or higher for whatever reasons. But if there's any dispute about the price, that valuation that we order is what is used as the baseline. And that's across all 3 rights to buy. It's the same steps on that. And that's a full red book valuation. So everything is valued. It's not a walk by, it's a full red book valuation under RICS rules. The ballot, at this point in the part 2, you've now triggered. So the ballot that was done earlier in the other 2 parts is now required under part 2 because you've now moved into the purchase. Same conditions though. Ballot the whole community, 50% turnout. The difference under part 2 is that we will pay for that ballot up front. We will appoint the balloter, who will then work with the community group to determine the question, who's to be balloted, etc. But we'll pay for that and we'll instruct the balloter. So under part 2, because we've already had the registration and we know about the case, we can do that. And the other parts, the first we get it is the application, which has to have the ballot attached. As I said, those 2 parts already had that submitted as part of that application. So for all 3 parts, when it comes to purchase, the whole community must be given the chance to comment. Under part 2 for registration of interest, you can ask for a petition, and obviously generally only the people who are in favour will sign the petition. So it's not the whole community, but under the purchase, when you reach the purchase stage in any of the acts, the ballot of the whole community is what matters. They've got to be given the chance to have their say. Now for part 2, we've then got 21 days after that trigger and the ballot and everything come in for us to make that decision. What we will do as part of that, we will go back out to the group and ask them for additional details on things like business plans, costings, and things like that. In other words, tighten up the original application on what they plan to do, because now they're moving to the purchase stage. So we need those details. Those should already be in the part 3 and part 5 applications because you're moving straight to that. For parts 3 and 5, remember you've had 60 days for the owner's comments, 60 days for the 60 days for the owner's comments, 60 days for the community groups. We now have to take at least 60 days to make our decision under either of those 2 parts. So in total for the various pieces of legislation, for the part 2, an application comes in, 21 days for owner's comment, 21 days for the groups, 21 days for us to make a decision. So 63 days after the application, the group's interest is registered. Once it gets triggered, then that moves to 21 days to us to make a decision after the trigger. Under parts 3A and 5, you're talking about 60 days for the community group, 60 days for the owner, or rather 60 owner, 60 community group, and then at least 60 days for us to make a decision. That's 180 days since we've had the application. So you're talking about 6 months from receiving the application to getting our decision. Keep in mind as well that before that, in the 6 months prior to the application coming in, the group must have either tried to buy or tried to transfer, depending on which part you're using. So it's not a quick process, and it shouldn't be seen as that. It's not there to quickly get a hold of the land, because all of a sudden it's become available. So groups should try wherever possible to be as proactive as they possibly can in thinking about what land they might want to use for what purposes, and start thinking about whether or not any of these parts are useful for them. So it's not a slow process, and again under parts 3 and part 5, it's not a way to grab land off owners as it's been accused of being in the past. It's an open process. The owner has had a heads up that groups are interested in land, whether it's through the transfer or the trying to purchase rights. There's then 6 months between the application coming in and us making a decision, particularly in the abandoned and neglected case, for the owner to deal with the issue. Because at the end of the day, if the issue is detrimental, and say it is the flooding example used earlier, the owner fixes the problem, then there's no need for the community group to acquire that land anymore, because the only reason for acquiring it was to fix the flooding that the owner is refusing to do. So groups shouldn't be surprised under abandoned and neglected if the owner fixes the issues the group have raised, and therefore it is no longer abandoned and neglected. That is one of the, as some see it, downfalls of Part 3A, but at the end of the day, its aim has been met and it's brought the land back into productive use. It is no longer abandoned and neglected. Part 5 is slightly different in the sense that that's about furthering sustainable development. So if you like, there's less that the owner can do to fix that because there's nothing to be fixed. But one of the things, there's 3 tests under Part 5 that are quite key, in that the land that the community group are looking to apply for must generate a significant benefit for the community. And it's important that that word significant is in there. It's not just a little fix and a little bit better or stays the same. Their plans must result in significant benefit. The land must be the land that only or most practicable way of achieving that benefit. So if there's other land they could look at, they should look at that other land. And the final one, and probably maybe the hardest, is that if we refuse the application, it must be likely to result in harm to the community. So again, if we get an application in and if we refuse it, things will stay the same. There is no harm. So there must be some harm. So again, it's about furthering sustainable, because there will be harm caused to the community. So that's why you need that land to prevent that harm, to further sustainable development, to create a significant benefit. The reason that those tests are in place, and they may seem overly restrictive to some, is that for both Part 3A and 5, we are putting in place a compulsory purchase. In other words, we are interfering with somebody's property rights. Now, under European legislation, again, it's because quite often been thrown at us, you can't do that. Well, actually, we can. But member states must have good reason for doing so. So the government can interfere with somebody's property rights if it has good reason to do so. What we're looking for under these tests is for the community group to give us what those good reasons are. You tell us what your good reasons are for interfering with somebody's property rights, and we will allow you that right to buy. If you don't have good reasons, then you won't. So that's why those tests are there. They're not there just to put red tape in the way. They're not there to make it more difficult for groups to acquire land. Far from it. What they're there to do is to make sure that if we go through this process, it will not be thrown out by a court because we didn't have good reason to interfere with rights. The good reasons are there. That's why we're giving you the right. We need to be able to defend any of our decisions under any of these parts under appeal in court. So we need to make sure that the good reasons are there. And then once we've got your decision, you have a period of time in which to conclude the purchase. That period can be extended by agreement between the group and the owner. And the owner is not allowed to unnecessarily delay that process either, or the court can make an order to take it forward anyway. Under Part 2, you're given 8 months. Under Parts 3 and 5, you're given 6 months. So things like funding for your purchase, start that process before you get a decision. Give yourself as much time as possible to essentially do the paperwork. But those periods can be extended by agreement. And I think that was that. Now I will try and stop sharing my screen. I will now turn my camera on since we go into questions.
Great, thanks, Dave. Yeah, brilliant. I can see you and I can hear you. I'll turn my camera back on as well. It's Elsa Rayburn again. Hopefully you can all hear me. Yeah, thanks very much, Dave. That was a really useful overview, and I've been involved in a few of these cases, and I think being able to compare the different rights under the different parts of the legislation was really useful. So I'll certainly go back and have a look at that slide again. It is quite a complex area, as you will have seen, and there's lots of different stages, but as Dave's outlined, that's really to protect both landowners and communities and make sure it's a really fair and transparent process for everyone. So there are some case studies out there of communities that have been through this process, and we always urge you to speak to other communities who've been through the process. And as Dave's already mentioned, there's lots of support and advice out there for communities, either directly to Dave's team in Scottish Government or through Community Land Scotland or through the other intermediaries like Community Woodlands or DTAS or POS. So I think some of the new legislative routes that Dave's outlined there, particularly around abandoned and neglected and acquiring land for sustainable development, are really exciting, new, innovative areas. And as I said at the start, the Scottish Government are really leading on this in terms of giving communities powers and resources to acquire land to address issues in their own locale. And it's very much a bottom-up approach. So it's not the local authority telling you what you should be doing, but it's the communities themselves identifying issues with land and buildings in their area and giving them the power and the resources, as I say, to try and address that. So I'm going to turn to questions now. I don't know whether I'm not seeing it, but I'm not seeing any questions at the moment. Is that right, Christina? Can you put your thumbs up if that's the case?
Hi, so we don't have questions in the chat box, but there have been a few raised hands, so maybe we can invite those folks to just ask their questions in person. So I think it was Michelle Good was the first one. So if you want to just unmute yourself, Michelle.
Hi there, how are you doing?
Hi.
Sorry.
Hi, Michelle.
Hi. Sorry to sorry about all that noise. My question is, I'm really grateful for that really comprehensive view, as also with the previous webinar as well. I think the table was really handy, but there was so much to take in. My particular focus is on the part 2 element for a community group that has the potential of a collaborative approach to taking on an asset with, for example, the Crown Estate, so enlarging that portfolio. So my question is there any resource that will show a timeline of what was in that table, so I can try and sort of plot where the groups are at, etc.? Is that something that's possible?
Oh, Dave, you're muted, sorry.
That should be better, sorry. Yeah, I think a timeline is something we've tried to put together several times, and trying to draw a straight timeline is difficult because there's so many ifs, ands and buts. But what there is available are roadmaps that have been produced for all the rights to buy that gives groups a chance to sort of plot around the route, as it were, to see what the next steps are, where they need to go to next. That gives some clarity to that, but a strict linear timeline is quite difficult. But Michelle, if you want to get in touch, we can see if we can pull something together that might help you on that one, or I'll try and remember and have a dig around. But it's not something that's a straightforward linear process, because it all depends on whether it's late and whether comments come in, and etc., etc.
Perfect, thank you. And is there, I mean, I think I feel sorry for you all guys. I think you'll all get me at one point or another, just because I'm super excited about speaking to you all. Is there a contact details that I can get? Will that be sent in the links to this webinar and any other resources relevant?
Yeah,
absolutely, Michelle. Yeah, we'll send that, and together with a copy of Dave's presentation, if he's happy with that, with those tables, and also links to the route maps that Dave mentioned, because so they're really useful to sort of work your way from the start to the finish and understand all the different phases in each of the processes. So they're a really good visual guide to that. So yeah, we'll send all that out afterwards.
Thank you very much.
Thanks, Michelle, for that question. Christina, have we got someone else? I haven't got everyone on my screen. So
Okay, yes. So Cliff, if you wanted to unmute yourself and ask your question. Is that working? Hello?
I think we should be able to hear you, Cliff.
Oh.
Oh, you've muted your...
Hi, Cliff. I'm afraid you're muted still, so can you press the unmute button again on your screen? You're still muted, I think.
I think we can unmute you from here. Oh, there we go. I think that should work now.
Go ahead.
Hello.
Yes.
I was about to ask if these 2 screenshots would be available to us. I've been making notes as I go along, but it would be very good as a summary to have access to these. But you said you're going to send these out.
Yeah.
Screenshot.
Yes, absolutely.
Certainly. Yeah.
Thank you very much.
There are no other questions at the moment that I can see. It's quite a lot to take in, isn't it?
It is. It's a really complex area. Thanks, Christina. Well, as I say, we'll send all the details, and Dave's kindly offered to answer any queries directly after the webinar. So once you've had a chance to look through it again and digest all the information that's in there, then do get back in touch. But I think if we don't have any more questions, we'll finish up there. I'd like to thank Dave again for his time today in explaining some quite complex ideas and processes. And we look forward to seeing you all again at the next webinar, which Christina will tell me the time of now.
Yes, it's 3:30 until 4:30, and it will be in partnership with Community Ownership Support Service, and it will cover all things asset transfer. So you're welcome to join us.
Brilliant. Okay, thanks everybody for joining us today.
Thank you.
Thank you. Cheers.
Bye.